first case to come before us this morning is State versus Black, and each of you will have 15 minutes to present your arguments, and the appellant may reserve up to 5 minutes. Please let me know how much time you want. I want to remind everybody that we are videoing, that will be on the YouTube channel, and please stay behind the lectern, and also please keep your voice up. I have to remind myself of that so many times. And then please do not mention the names of any victims or any children. So other than that, we're ready to listen if you are ready to proceed. Mr. Van Dyck, you ready?
I am over here. Good morning, Your Honor. I am, please the court, I am Alan Medved. I am here representing the appellant, Adarus Black, in these matters. I would reserve 5 minutes for rebuttal. And I am here representing Mr. Black on his appeal of his convictions at the trial level, and I've raised 3 assignments of error, all essentially intertwined. One, that there was a plain error on the court's and trial counsel's part in not requesting a Daubert hearing for the purported expert from CyberCheck, App.No. Related to that, but also even if Mr. Mosher's testimony were found to be valid, issues of insufficiency and manifest weight, that the state failed to demonstrate sufficient evidence to convict Mr. Black in these matters, or in this matter, or that there was, that the manifest weight of the evidence was against the conviction. And I would start out talking about the CyberCheck report reported to be created by Mr. Mosher, and the lack of any Daubert hearing in that matter, and the fact that his evidence was clearly expert evidence, that it was not held to a Daubert standard, and it was prejudicial to not have such a hearing in this matter. Let's start. Arthur C. Clarke once said that any sufficiently advanced technology is indistinguishable from magic, and I think the problem with that is that we as lay people can't tell which is which, and one of those is real and one of those is not. And that's why we have evidence rule 702, is to establish a pattern for how we're going to distinguish between what is advanced technology and what is magic. And in this case, that test was not done. There was no evidence there was no prior objective evidence presented regarding Mr. Mosher's qualifications, his CyberCheck program, its reliability, any objective testing that had been done in the peer reviews. As far as the record shows, none of those things exist. And this was a person who was presented at trial as an expert, and who basically gave what amounted to what he claimed was essentially DNA evidence, putting my client's cyber profile at the location at the time of the offense. And
what is the difference between this and, an officer testifying about cell phone records?
One of the things that is different is that, and I think Mr. Mosher has testified, that he is doing a much deeper, much more intense dive into his claims are that he is doing, that his program is doing a full dive into every moment that you're on the phone, whether you're using it, whether you're on a call or not. And the other thing that is not present is the data, and that again, cell phone tower and reading those algorithms, reading those charts, and being able to triangulate, that is It's not an advanced technology. That is something that, as you say, a police officer, someone even as dumb as myself might be able to sort through those charts and say, yes, I could repeat that evidence. There's no evidence in the record that this could be done, and there's no evidence anywhere that Mr. Mosier has presented this evidence outside his own statements in these trials, in this trial, that he has done this before or that this has been tested. There was no record of how this was done. No one has a possibility to actually figure out how to repeat this. I mean, I would say that is my first distinction. There are also distinctions, and these have been raised in other courts, regarding what might be protected information, what might be, whether he obtained this information in violation of a Fourth Amendment right, of a search and seizure issue, of a privacy issue, that we don't have that data, that data was not inquired for here. The ability to try to respond or address this data was not provided.
I guess when I'm wondering, the reason I asked what the difference is, because I know the overall difference, but as you said, everyone knows what the cell phone, but they didn't when it first started.
Right.
People didn't know magic. The cell phones were magic when they first started.
And
they still are to me, as far as I know.
right. Cell phones were magic, x-rays were magic, DNA tests were magic. The issue is that at the time, I am not saying that it may not be possible, either now or at some point in the future, to do what Mr. Mosier claims to do. But what has not been done in this case, and what I don't believe Mr. Mosier has been able to establish in other cases, there is trial authority out of this county and several other cases where daughter hearings have been held, and most of those have currently excluded Mr. Mosier for being unable to meet the daughter standard. That would be the Javion Rankin case, which is up here as on appeal currently, but the trial number is CR 2021-04-1284A. Antonio Miller, CR 2022-09-3351. State vs. Carr, CR 2023-01-0239A and B.
Can you clarify, Rankin is pending?
What's that?
Rankin, that issue's pending.
Rankin is currently pending, but the trial court, it is pending because it is here on an interlocutory appeal because the trial court held that Mr. Mosier could not meet the Daubert standard.
I see, so you're.
I am providing persuasive evidence, and I'm providing.
I don't think Rankin had a Daubert hearing.
Rankin had, fortunately, I am second chair on Mr. Rankin, so we did have a Daubert hearing on Rankin.
Okay.
And then additional evidence has been required, and this has been a problem even in the Mendoza case, which Judge Croce found he was qualified, but that he has not provided a lot of the follow-up evidence that he has stated he would provide. That matter is still pending.
So the clarification was, these are all matters that the trial court has made a ruling, but the appellate court hasn't.
You have not yet made a ruling. I think the only other case that has been up here on the Daubert on this issue is a similar case, Mahdi, which we'll talk about, where this same issue was raised, where a Daubert hearing was not held, and the appellate counsel had stated that it should have been, and you found that there was no clear error, that was not clear that in the absence of Mr. Mosier's testimony, he would have been found guilty. So let's hop ahead to that part right now, because I think it is clear in this case that without the cyber report and Mr. Mosier's testimony, that the outcome of this case would have been different. That there is a great deal of evidence that puts Jayon Bivens in that vehicle, and that has Jayon Bivens driving that car and going past the location and that his car fired that gun. That's undisputed.
Isn't there also evidence that Mr. Black was with him on that day as the passenger?
There is evidence that Mr. Black went to a party. There is evidence, there is not evidence that there is allusion to the idea that Mr. Black and Mr. Bivens they're left to buy a t-shirt for Martell. There is not evidence that Mr. Black had a gun, that anybody set out with the intent to commit this grievous crime. I'm not disputing that this is tragic, that this is an awful, awful set of facts. And I don't want to dispute that, but I also want to make sure that this awful set of facts does not result in the adoption of bad law or the adoption of a relaxed standard for allowing what I think is highly questionable expert testimony in, and resulting in a second tragedy by locking up someone who is not guilty of this offense or cannot be shown guilty beyond a reasonable doubt, which has not just a harm to Mr. Black, but has an impact on our entire culture and our entire legal system. And at this point, right now, I understand, and what we have been asking for in all of these cases, and what we're asking for here, is that Mr. Black, Mr. Mosier needs to show the work, that we need to know that this is not magic, that that's what we're asking. The question you have is a question that we all have, is how do I know that you're not just throwing some newspaper in a hat and then pulling out a rabbit? You know, that, I mean, that's illusion. And what I have here is no chance, no one challenging that at that level. And it's been clear when it has been challenged that there are significant questions about Mr. Mosier's testimony.
Counsel, you are in your rebuttal time.
Then let me wait. Thank you.
You were on a roll, so I didn't want to stop.
Good morning, may it please the court. Kevin DiMartino on behalf of the state of Ohio, the appellee in this case. We are asking that this court affirm Mr. Black's conviction for murder. Mr. Black has not shown and met his burden at the trial court erred in admitting the testimony of Mr. Mosier and Cybercheck. His burden is to show that the outcome of the trial would have been different if the evidence was not admitted. And opposing counsel acknowledges that this court very recently on December 27th in State v. Motti, 2023, Ohio 4763, was faced with the same question, which is, was there plain error? And that defendant also argued ineffective assistance of counsel when Cybercheck and Mr. Mosier's testimony is introduced without a determination under 702C or a Daubert hearing. And this court held that Mr. Motti did not meet that high standard of showing ineffective assistance of counsel or plain error because there was other evidence. And
So
we,
what is the other evidence?
I was going to say, so I'll agree to disagree with opposing counsel as far as what that other evidence is. The record will show that there was surveillance footage, and it sounds like the appellant is acknowledging that the vehicle was used in the crime, and Mr. Bivens was driving the vehicle at the time of the crime. And the only issue is, was Mr. Black in the Camaro at the time of the shooting at the corner of North and Howard? So there's testimony from Miss George, which is Mr. Black's half-sister, I believe, or stepsister, that Mr. Black and Mr. Bivens spent the night at her house, and they had that car. So the night before, and they had that vehicle in the morning. Mr. Spragley told the police shortly after the crime that Mr. Black and Mr. Bivens were at the house in that Camaro, that they left together to buy a t-shirt, and they returned together with the t-shirt. He did testify at trial, you know, his memory was spotty at this point, but there is that evidence. There's also the surveillance footage from the store, outside the store where the shirt was purchased, that Mr. Bivens gets out of the car. The surveillance footage that shows the drive-by shooting shows the car, and that the shots are fired out of the passenger side, that they're linear like a drive-by shooting, and then coming back from behind as they pass the car. So you have to take all that evidence and put it together, and Sergeant Stravaghi introduced a video, demonstrative aid, that basically shows the path of all the surveillance footage that we were able to obtain, which shows this black Camaro following a white car, and then eventually the white car that the victim is in. So when you piece that all together and you have the testimony, it puts Mr. Black in the passenger seat of that Camaro before the crime is committed and returning to the house where he left in the Camaro after the crime is committed with the person who bought the t-shirt. So there's circumstantial evidence that puts him at that crime. And then, of course, the cyber check data confirms that both of their cyber profiles, not their phones, but their cyber profiles were at that intersection within a few minutes of the crime. So there is sufficient data that supports the conviction outside of the cyber check information. Therefore, this court doesn't have to get to the issue of is cyber check and Mr. Moser's testimony, expert testimony, and was it properly admitted.
So if I may, the evidence is that Mr. Black left with Mr. Bivens to get a t-shirt, which the cameras showed that Mr. Bivens was there, but evidently Mr. Black wasn't on the surveillance camera.
Just the driver's side.
Okay, then the car was, there's videotape that it was the car that was used in the drive-by shooting, and Mr. Black returned with Mr. Bivens in the same car.
Correct. All in a short period of time.
That is the extent of the evidence, other than the cyber check.
And the evidence, people saw them get in the car together, they got out of the car together, that multiple people have established that he was the passenger in the car, the shots were fired from the passenger side of the vehicle, it's all close in time. There's no evidence that anybody else ever got into the passenger seat, or that there was, time for him to then you would have to believe that Mr. Black then got out of the car somewhere, someone else got in the passenger seat, they did the drive-by shooting, and then that shooter got out of the car and Mr. Black got in the car. And then
Or
after
that they
that-
took out somebody else.
But there's no evidence to support that.
I understand, but I'm just saying.
So the evidence that was introduced, that is what the evidence is. Could they make that argument? Is there speculation? Sure, but the manifest weight of the evidence that was introduced, that is what the evidence was. And the state believes that that is sufficient evidence. It puts him in the vehicle, he never gets out of the vehicle, there's no evidence showing the car stopping, any of that surveillance footage doesn't show anybody stopping, anybody else getting in the vehicle, there's none of that. And there's multiple surveillance that they put together.
Okay, and I understand there is a break though in surveillance at some point.
There's a break because the surveillance footage is whatever they could get from the businesses. So it's not a continuous, there's definitely not a camera on the car the entire time, absolutely. And that would definitely be their argument. But we do have the evidence that he gets in the car, he returns with the same person in the car, and they have the shirt.
Was he charged as the shooter or complicity?
There was complicity in there for sure.
But Mr. Bivens had deceased before the trial,
Correct.
and there was no preserved testimony before his demise.
Correct. Yep, there are a lot of unfortunate events with regard to this case, absolutely for sure.
With respect to the videos from the businesses, specifically the one from the intersection where the shooting occurred, can you see the driver of the vehicle? I mean, even if you can't make that person out, can you see the driver?
You can't really, you can't make it out, but you can tell it's this Camaro, and you can see as it goes by the dust and the paint
Sure.
from the shot being fired. So I think that the only issue really before the court is about the identity of the shooter. There's no dispute that the shooter was in the passenger side of the vehicle.
Why is that not disputed? Just by the expert testimony of trajectory?
Because as the car passes the white car, the shots are coming not from the driver's side, but from the passenger side.
And also one back.
Right, and one back,
So theoretically, the driver can't make that.
based on the testimony.
Okay.
Right, so that would be the evidence that was in the record. that it
Isn't
was-
there disputed evidence because there was a witness who said the shooter was white?
And there was testimony that they did not take that person's testimony to be accurate, and they understood. He also said that the car was a Mustang instead of a Camaro, and they were able to testify about that. So they did explain and articulate why the police, when they took that person's testimony, that they did not believe that person.
But that person did not testify on behalf of the defense at trial? Or-
No.
Okay.
So even if this court was to find that they had reached that high burden of showing that the outcome of the trial would have been different if CyberCheck had not been admitted, then we get to the issue of, is CyberCheck even scientific? So at the time, and I'd just like to side note that opposing counsel brought in a number of things that are outside the appellate record, and I would ask the court not to consider it, including trial court decisions in other cases and evidence that's outside the record, even in Rankins, because those things he is talking about happened after the appellate record was filed in the case. So I would ask that the court not consider any of that. So at the time, now I just said that and I'm going to tell you something outside the record, right? So when CyberCheck first came about, it was put as, basically it's like a big bucket of sand and you're sifting looking for one grain. And Mr. Mosier is able to basically sift through all the sand and find the one thing you're looking for. The testimony, that's just my take on it. So I personally, at the time especially, did not think that it was necessarily expert evidence. Even now, when you read Mr. Mosier's testimony, you have to remember, he's not testifying in a Dauber hearing. He's not trying to prove the science and is it reliable and was the test done in a proper way. He's talking about what is CyberCheck and what have you done to make sure that it can, be replicated. And he talks about the fact that he's had this case, the CyberCheck data for a number of years, and since 2017, that 345 law enforcement agencies have used it. There's been 24,000 law enforcement searches. Those things are actually in the record. He talks about how he gets all of the data is from open source information based on your cyber profile. So I would again respectfully disagree with opposing counsel's assertion, especially in the brief, that a cyber profile is either something Mr. Mosier made up or something so complicated you need an expert. I think everyone knows what a cyber profile is, especially in 2023, 2024. The issue is how is he sifting through those grains of sand to get to that one piece of sand? And I understand that the opposing counsel, they want to see his proprietary work on how he gets it. He has testified how you can replicate it. He testified even in this case that they had humans go ahead and take the data and come up with the exact same result as what his algorithm does. So he has demonstrated, even though he wasn't put on as a 702C expert per se, and there wasn't a Dauber hearing, he did testify as to how CyberCheck reports are created. It comes from a cyber profile, how if you have full profiles, that is 99.9% accurate, that he only uses information if he has an 80% or higher reliability factor. The fact that these humans were able to replicate the same result as his software shows that it is reliable. So based on those things that are in the record in this case, even though Mr. Black did not argue or challenge any of the testimony, there's no objection, we're clearly in plain error, the record would show that it would meet all of the requirements under 702C, and if there had been a Dauber hearing, there's nothing in the record to suggest that the court would have found that it was not in accordance with the Dauber standard based on the evidence that was presented. Certainly, if they had asked for a Dauber hearing, they could have asked other questions perhaps and tried to attack what they believe is magic or some kind of junk science, but they didn't do that. And now they're asking you to perform some magic, which is to take a lead from all the cases on plain error and get into the weeds of, is this expert testimony, and should a court be either sua sponte ordering a Dauber hearing when defense counsel doesn't ask for it? For all we know, they knew what the CyberCheck report showed, and they just thought, we'll cross-examine Mr. Mosier and make it look like it's junk science and magic, and since they believe there's not a sufficient amount of evidence anyway, maybe that was part of their trial strategy. We don't know. But they are asking you to go what is really beyond all the cases and the precedent with regard to plain error, and certainly the precedent that this court set in State versus Motti. Based on that, this state would ask that you find that there was no plain error in this case and to affirm Mr. Black's conviction.
Counsel, we'll see in the record, obviously, once we read the transcript, but I know they didn't request a Dauber hearing, but did the witness testify that he had appeared as
don't recall the word expert being in the transcript at all.
What's his background? Is he a cybersecurity major?
He is in cybersecurity. I would have to go back and look and say it exactly correctly because I don't want to get it wrong. But he is definitely in cybersecurity, and he is the CEO of Global Intelligence, but it is definitely in cybersecurity.
And then just a follow-up question on this whole scientific part of this, and that is, that we talk a lot about AI. So when we're talking, and we're now defining AI very broadly, would this be more, I mean, do you think it's more like AI when we're talking about algorithms and using a program?
I don't think it's anything at all like AI. His computer is able to basically, your phone, anytime, everyone has some app on their phone, no matter how basic your phone is. Every time that phone is trying, there's an app on there, it's always trying to connect to the internet. So it's that connection that's being left on the internet, not something AI.
So this is more like investigation with specialized knowledge, like a person who knows more about computers is doing the investigation, you're thinking. You think it's, I mean, that's what is that what you're saying?
Yeah, I think it's very much like Judge Carr pointed out, it's very much like the cell phone towers, except it's not hitting off of a tower. So it's just someone else that can figure out when something is connecting to the internet. I couldn't do that. I think a lot of other people much younger than me could probably do that. It's all open source, so you don't even have to get, a subpoena or anything like that. So when they're talking about whether privacy issues or anything else raised, that's all pure speculation. It's not even, at the heart of what, it certainly has nothing to do with a Daubert hearing.
So your position, the state's position is not even expert testimony at all.
Correct. And if it is, that it meets 702C, and it certainly would meet the standards of Daubert if there had been a hearing. But it is unfair and contrary to precedent to allow a defendant to not challenge, no objections, nothing about the testimony, not argue that there's an expert, not have a Daubert hearing, and then come in here and challenge what the state presented when we're presenting a witness's testimony, and then say, well, they didn't present enough. Well, if you had just objected or raised anything, we could have introduced more evidence. If you had asked for the Daubert hearing, we could have put on our evidence.
Counsel, you're out of time.
Thank you, Your Honor.
Meeting has just a little over 4 minutes.
Thank you. I'll try my best to be quick. Let's start with the last thing. Yes, absolutely. That is my point. That's why this is a plain error case. They should have asked for a Daubert hearing. They should have objected to this testimony, and they did not. And it is that error, that failure to have such a quick hearing and to have such an objection that has led us here, because without Mr. Mosher's testimony and expert testimony, we would not be here right now, because there would be insufficient evidence. I think that is clear in the record, that Mr. Black would not have been, I think it is clear that there would have been a different result in this case. And to talk about the many witnesses placing Mr. Black in the car, there were 3 fact witnesses by my recollection. One, Ms. Gordon, who was not at the party at the time, who said that Mr. Black came back, was in the car at some point, not close in time, not even close in time to the day before, later that day, not close in time to these events at all. Then I think it's Martel, and then Mr. Spraglin. I think Mr. Spraglin is the only one who, at any point in this process, and that's not through his testimony there, I believe that's elicited through recollection testimony, that he says in the record, all I know is I had somebody get a t-shirt and they came back with a t-shirt. That is the evidence. There's no evidence of, and what there's a total absence of, is that either Mr. Black had a gun, fired a gun, was even complicit. As is stated in complicity instruction, mere presence, even if you could place him in the car, which is the best that this cyber profile can do, there's no evidence that he was of any mens rea, of any purpose, of any reason why, if Mr. Bivens or some third person who could have been in the car, at any point, even if Mr. Black was in the car, was the trigger man. There is no evidence to support this, and it is solely but Mr. Mosher's evidence, and that's why I think even in the absence of, even if in the presence of Mr. Mosher's evidence, the testimony, there is insufficient evidence here of Mr. Black's conviction. But the only thing that places him, or anything associated with him in that car at the time of the offense, and this includes all of the video evidence that's been referenced, all of the witness testimony, every other piece of evidence does not place Mr. Black in that car. The only thing that does so is this alleged cyber profile. We'll ask you to read Mr. Mosier's testimony of it itself, and it is clear that Mr. Mosier is holding himself out and has been brought in as an expert. He is being paid by the Akron Police Department and the prosecutor's office to be there. He testifies as to his qualifications as a cybersecurity expert. He testifies to the nature of the program. He's an expert not just in cybersecurity, but in this program itself and how this program works. And finally, he is asked at the end whether his evidence and testimony reaches the level of scientific, reaches a level of scientific reliability. The things we do with expert testimony. Regarding the other cases that I referenced, I would hold that is supplemental. I'm not referencing things in those hearings. That is supplemental authority. I can, much like with Marty, if you need me to supplement that on the record by motion, I will do so.
Well, we're gonna be looking at that eventually anyway.
And I believe I have enough time. I will close with, there is a current adaptation of Mr. Clark's statement that any sufficiently advanced incompetence is indistinguishable from malice. And I would say that that is where we are here, that we are faced with a situation of plain error that has led to an egregious outcome, and I would ask this court to reverse the decision.
Thank you.
Thank you.
Thank you both for your very thorough and interesting presentations this morning. And the court will take the matter under advisement and will issue a written opinion that would be sent to both sides as well as released on the Supreme Court website.
Thank you very much.